Good morning, everyone. My name is Mohammed Abduroaf. I'm a practicing advocate in Cape Town. I specialize in family law matters, child custody, child maintenance, relocation, guardianship issues, etc. Today is our fourth webinar in Women's Month dealing with child issues, family issues. The previous webinars dealt with child maintenance. Another webinar dealt with the issue concerning culture and child maintenance. And a further webinar, the first webinar dealt with child custody. So today we're following on with the webinars. We were specifically dealing with the issue concerning child custody and relocation. Before I proceed with discussing that issue and answering questions that were posted to us when the participants registered for this webinar, I would like to give a bit of an introduction on the topic. So when we're dealing with the issue concerning child custody, we're dealing with the issue regarding parents having care and contact and rights of supervision over the child. So where the child will live with one parent for one day and with another parent for the other day, or weekend contact, shared contact, etc. Regarding the issue of relocation, this webinar won't specifically deal with the issue of relocation in relation to provincial relocation. For example, from the Western Cape to Gauteng. We'll deal with the issue concerning relocation from one country to another country. But we will also look at the questions that were posed, and I don't see many questions that were posed regarding that specific topic of international relocation. But let me first begin with welcoming each one of you. Thank you for partaking in this webinar. And we will have one or two more webinars for the rest of the Women's Month, so you will be informed about that. When we're dealing with the issue concerning child custody, it's important to understand a few basic concepts. One concept would be that one parent does not necessarily have more rights over the child than the other parent. So for example, a mother cannot say, I have more rights over the child than the father, or the father can't say, I have more rights over the child than the mother. Or the one parent can't say, because I'm supporting the child more than the other parent, that I have more rights over the child. For example, one parent is paying for all the child maintenance, the school fees, the extramural expenses, etc. So that will also not go well. The basic concept is that both parents have rights to the child, but when it comes to disputes, we have to determine what is the best rights of contact, care, guardianship we should give to the parents based upon the dispute. For argument's sake, if parents are divorced, or they're separated, or they don't live with the child lives with one parent predominantly and with another parent and for the rest of the time. You can't say that one parent has more rights to the child because the child lives with one parent predominantly. You can't say that. You will have to basically say, under these circumstances, because of the situation of the matter, the child having two parents who are separated, who do not live together, it would be in the child's best interest if one parent primarily cares for the child and the other parent have contact with the child, every second weekend and half school holidays, or midweek contact, etc. So we must get out of our minds, and many people believe that I have more rights to the child than the other parent. The only time we could possibly say one parent has more rights to the child is when a child was born and one parent was not involved in the child's life since the child's birth. And 10 years later, this parent comes out from nowhere and says, I now want to have, rights to the child. In terms of the Children's Act, if a child was born out of wedlock, and that is a situation, a parent will have to acquire parental rights and responsibilities. For argument's sake, if a father made a mother pregnant and he was nowhere to be found, years went by, he comes back into the picture, he needs to now be part of the child's life. He needs to maintain the child, support the child, have contact with the child. And if he does that in a reasonable period of time, and he forms a bond with the child, then automatically based upon that, he will acquire parental rights and responsibilities. Then he can say, I now have rights to the child. But he cannot say, I have rights to the child, whereby now I want to have custody over the child. We will have to look at this matter holistically, and we now have to determine what type of contact rights he can have based upon what is best for the child. So if it means now that, although he only came into the child's life a few months ago, or a few years ago, but it would be best for the child to actually live with him, then it is possible under those circumstances for a court to make an order, although the child only knows this person for a few months or a year or so, it would be better for the child to live with a specific person because it is best for the child. I think that's very important to note. And then obviously the court will make a ruling regarding how contact should be with the initial primary caregiver. Then before I go on, we get a lot of queries. Many people ask me this question: how do I get custody over my child? And I think those are some of the questions that have been posed. And the basic scenario is whereby the mother, she has a child, she knows the dad. The father is not much involved in the child's life, or not at all involved in the child's life for the last, let's say for argument's sake, 10 years. Now the mother contacts us and says, I would like to have custody over my child. So the easiest way for me to deal with that situation would be to ask the mother, what is your definition of custody? Now, her definition of custody is, I want to have the sole say regarding what happens to the child, and the father must have no rights whatsoever to the child. Now, my second question to the mother would be, aren't you already exercising sole custody because the father is not in the child's life? You're the only one that decides what's best for the child. So aren't you already having custody over the child? So the basic way to deal with such a scenario here is to ask the mother or the father, whoever the party is, would you prefer having a court order stipulating that, confirming that you have custody? And generally that is the response we get. Yes, I would like to have a court order confirming custody. Then we go back again to determine, is that in the child's best interest? Is it best to say, okay, although the father was not in the child's life for a long period of time, or we say for reverse, let's say the mother left the child with the father and she went missing. The question is, would it be in the child's best interest for a court to make an order that the mother has a sole say as to where the child should reside, who the child should have contact with, the day-to-day activities of the child, and the father has no right regarding that? So it's a case-by-case situation, and the court will have to decide what's best for the child under those circumstances. If the situation is where the father was not involved in the child's life since birth, and the mother is afraid that the father might one day come and say you want to have contact with the child, I doubt the court would, for the sake of giving an order to the mother saying, ma'am, you have sole custody, because if the father does come to the picture 10 years later and he wants to have contact with the child and the mother refuses, the court will still have to do its inquiry then. And I would advise the mother to delay matters until that time, where the proper inquiry can be made at the time when the father does now decide to exercise some type of contact rights to the child. Then we deal with the issue regarding guardianship. Now, many people, they have a misunderstanding regarding guardianship rights and contact and care rights. It's two totally different situations, where one parent can have no rights of contact with the child. He's not allowed to see the child, or maybe under supervised conditions, but at the same time, he or she will have guardianship rights over the child. So guardianship rights basically deal with important aspects of the child's life, not contact and care, like when the child lives with you, but for example, the child applying for a passport, the child purchasing immovable property like a house, or the child leaving the country, going for a serious operation, etc., or applying for schools. So in terms of the Children's Act, there's a few requirements, a few points whereby both parents who have parental rights and responsibilities have to consent. For example, the application of a passport and for the child to leave the country. So that's where both guardians have to consent. For many times, people come to offices and say, I would like to relocate to a different country. The father never saw much the child ever since the child was born, but Home Affairs still requires me to get his consent. Yes, because the Children's Act says both parents have to consent to that. Yes, it's possible that this father was not in the child's life from the word go, and he might not have acquired any parental rights and responsibilities, but is that for Home Affairs to determine? It's basically, I think what Home Affairs does is they say, if that is an issue, let the court determine that, notifying the father about it, and if there's a court order stipulating that the child can relocate or leave the country, we'll happily let it happen. But until then, we're not getting involved in parental disputes. So guardianship deals with actual, rights or the life of the child from a holistic point of view, not necessarily from a contact and care point of view. So it's very important for us to note that. So if you do see your lawyer and we see your attorney and you say, and your concern basically is every time when I apply to a school when I apply for some extramural activities, when I go to the hospital, I have to continuously obtain the father's consent for this, because I require both guardians' consent. But the problem I have is his father is not in the child's life. He doesn't know the child. He sees the child only once every 3-4 years, or the last time he saw the child was 5 years ago. But still, I have to do that. Under those circumstances, I would say there are merits for a parent to approach the court and there to obtain sole guardianship rights over the child. So the other parent can still see the child maybe whenever it's in the child's best interest, in the second week, etc. But when it comes to important decisions like a passport, relocation, schooling, medical procedures, etc., under those circumstances, the primary caregiver of the child, if it is the mother, it could be the father also, but if it is the mother, only her consent would be required for that specific consent issue. For example, applying to a primary school or to a high school, as the case may be. Before we go to the questions, we will deal with the last aspect, just to put a bit of an introduction in, of relocation. So for the last 2, 3, 4 years, I've been receiving a lot of requests to assist parties regarding relocation to a different country. And it always ends up in court, where the court gives a court order stipulating that the minor child is allowed to relocate to another country for the removal of the child from the republic, because that's a requirement in terms of the Children Act. Both parents must consent. If both parents do not consent to it, the court can override that decision. And for any decision, the court can override. But for the relocation of minor children from South Africa to another country, if the other party does not give consent, an application will have to be made to the High Court, and the High Court will now determine what is best for the child. Now, relocation issues are very complicated because parties usually fight regarding care and contact, whether the father wants to see the child or the mother wants to see the child, etc., in a local courts, but they live close to each other. Maybe they live a half an hour drive away or in a different province, but that isn't an issue. With relocation, we're basically saying the child will now be removed from the Republic of South Africa and live in another country, for argument's sake, New Zealand, Canada, the States, the UK. And the possibility of the other parent who remains in South Africa seeing the child will be, the rights will be limited, whereby he or she will not see the child anymore physically on a daily basis, or on a weekly basis, or a monthly basis. So the court will have to now determine, is it best for the child to relocate? So how do we approach a situation like that? We will first have to determine, firstly, number one, is it in the child's best interest to relocate into the relocating country, whichever country the child is going to? Will there be specific facilities over there? Is there schooling? Is there work for the parent relocating? Is there medical facilities? Or whatever the child has in South Africa, can that be mirrored overseas? Will it be in the child's best interest to move over? But that's the first question you have to look at. The second issue you have to deal with is, why is a parent relocating? So there are a few scenarios that applies. One scenario would be obviously for work reasons. People move around the world very often for financial purposes. People get retrenched in South Africa. People are earning much less money, and they have to now go overseas. If that is the case, it's a very good reason. Now, the other question is, why can't you stay behind? Would it make a difference? If you're earning £1,000 that side and you're earning the equivalent in the rands in South Africa, that's one factor we have to look at. But moving on, another factor another reason why many people relocate is for personal reasons. For example, somebody remarried. One of my previous matters were whereby the gentleman was living in America. The mother is living in South Africa. Now she wanted to relocate with a child over to the States. So that is one of the issues we have to look where people leave for personal reasons, not necessarily for the child, a better life for the child or better life for the mother, but for personal reasons. And then obviously there are other reasons. For example, people, the expatriates, etc., and that's why they move back to their home country. So the matter becomes very complicated because are you now saying, if the court makes an order that the child should not be allowed to relocate, then what's the default of that? The default of that is the child will now have to live by the other parent. And the question is, can the other parent look after the child? If the other parent cannot look after the child, then obviously the court will have to now basically allow the child to relocate, because that's the only other option. But if it's possible to argue or to prove that yes, there might be good grounds to relocate in generally, but it's better for the child to remain here, and the child will actually be better looked after remaining in South Africa. And the parent that remains in South Africa can care for the child just as well as the other parent can care for the child. If such a case is made out, I think the court would actually, be in favor of that scenario where the child will remain in South Africa, having all his family, friends, schools, etc., in place, and then the other parent who decides to relocate because of remarriage, because of work purposes, can visit the child in South Africa. But as I said, now at the end of the day, the matter gets decided upon what is best for the child. For the child, not for the parents, but for the child. It's very important to decide. And if a parent says, now I'm the mother, I'm the father, I have a right, that doesn't really play much of a role. The same way that you obtain the rights, the court can take your rights away based upon what's best for the child. So I think that's a bit of a mouthful, and I think we can now start dealing with some questions that some people posted when they're registering. I'll just put it on the screen. Okay, the first question was how to work out per parent to contribute to maintenance as my ex is using I think that's exercise that he has too many expenses. Surely it is worked out on gross salary, etc. So I know where the question is going to. It's not necessarily a child custody issue, but I will answer the question. You need to look at, firstly, the expenses of the child, and secondly, you have to look at the income of both parents. So it's very difficult for a person to say outright the father should pay half and the mother should pay half, because for the father might be earning much more money than the mother. So for argument's sake, if the father is earning double the mother's salary, he must pay two-thirds of the child's expenditure. So the best way to deal with this matter is look at the child expenditure. Let's say that comes to, for a round figure, 100 Rand per month. The father, he earns a certain salary, but he has a lot of expenditure. He has a lot of expenses to earn that salary. He has to use a lot of money on petrol, cell phone, etc. So at the end of the day, he only comes out with so much money, and then he needs to live as well to feed himself. So we come to a certain reasonable figure whereby, and we look at that net figure, and that figure will be used to determine what would be a reasonable amount to pay for the child. Many people ask me those questions. Many times those questions will become hypothetical questions. I still advise everybody, still proceed with your matter, go to the maintenance court, and the maintenance court will now do a proper inquiry to determine what is best or what is affordable for both parents and in the child's best interest. Let's go further to the next question. If the father of the child is currently on trial for sexual assault of the child, the siblings, his stepdaughter, and him and his entire family had chosen to cut themselves from the child, 5 months old, now 20 months, through no fault of the mother, what advice would you give regarding custody? So we are lawyers. I see the question goes further, but I'll give a bit of a general answer. And I've copied and pasted the questions as given to take no substance from it. So we are lawyers. The judges are lawyers. Family Advocates Office, they got social workers and psychologists or system getting some type of answers. So before I advise a parent to limit child contact and child custody, or give certain contact rights, or allow certain things to take place, do not necessarily apply your own mind to it or the mind of a lawyer. Speak to a social worker, because those are experts that deal with child matters on a regular basis. So see a social worker, maybe visit the office of the family advocate, see a psychologist, and advise them, this is the situation, my child or my stepchild, or whatever the case may be, or this person has been sexually assaulted by this specific person, for argument's sake. My child likes the father or likes the mother and wants to have contact with the mother or the father, but what type of contact would be best? Based upon that specific advice, then you can determine what is best for the child. So if the expert says that, the father's been charged or the mother's been charged now for sexual assault, sexual harassment of a minor child, we don't advise the father or mother to have contact unsupervised with the child, then that must be your stance. And if there's a court order in place that allows contact rights, etc., then I advise you to make an application to court to have the specific court order changed or varied. But I do not believe that a parent should make a decision where limiting contact from one parent should be done without specifically obtaining professional advice. That's a bit dangerous. Where the opposite again, if a child never had contact with a parent for a long time, and the parent now needs to have contact with the child, and there was no specific reason not to allow it, then I would say you do not need to speak to an expert for that. Allow contact, which is reasonable. Okay. So let's go to the next question. What are the steps to apply for full custody? Same with my introduction early on, full custody, what is the definition of full custody? But if you want an order stipulating that only you can have contact with the child and you decide when contact should take place, then you obviously need to approach the court to get an order in that regard. But in many cases, when people pose questions like that, it already means that you're already practicing sole custody, but without a court order. The next question is, if I relocate to Namibia, where I'm originally from, if I get retrenched, maybe retrenched in South Africa, or a new job that side, my baby and his father is South African and I'm Namibian, how do I go about to move to Namibia with a son? So obviously, you need the father's consent to go back to Namibia. I would believe the child was born in South Africa. So if the parent does not give consent for that specific purpose of the removal of the child from the Republic of South Africa to go to Namibia, you do not also want to do it without the other parent's consent or without a court order. As I said now, you need to approach the High Court, and the court will now make an order that you're allowed to leave the country without the other parent's consent if consent is refused. So that's an application where the court will apply what's best for the child. Next question, I am the grandma. What can I do to see my granddaughter? Case is at the High Court, Cape Town. The father, which is my son, stopped with the matter, so my hands are tied. Advocate says I cannot go ahead, go forward to see my granddaughter as my son has a case in the High Court already. Please help. So I'm deferring when she says, or this person says, advocate. I think they refer maybe to the family advocate or her private advocate. It's not me. Okay, so in terms of the Children's Act, I think it's Section 21 and Section 22, if I'm speaking under correction, it deals with the assignment of parental rights and responsibilities and the rights to third parties. Now, it's very important to note the persons that have parental rights and responsibilities over a child, like custody, care, guardianship, etc., that only applies to mother and father, not necessarily to grandfather, grandmother, aunt, uncle, and niece. So under my advice to the specific viewer is simple. You have a right to apply to court in terms of the Children's Act for the assignment, I think it's Section 24, yes, Section 24 and 25, for the assignment of parental rights and responsibilities to yourself. And the court will have to determine whether or not that is in the child's best interest. So although your son has stopped with the application to court, you as a third party at any point can approach your court and saying, I need to have contact with this grandchild. I've always had contact. It is in the child's best interest to have contact with me as well. Please assign it to me. And we were successful in previous cases whereby aunties or yes, and grandparents in the past have obtained relief from the High Court, affording them those specific assigned rights, Section 24 and Section 25 of the Children's Act. Furthermore, let's go further. I am the mom and my 3-year-old son lives with me. I'm only pregnant with our second. I'm also pregnant with our second. There is no parenting plan as yet and no court order. We are working on a parenting plan, but there are nothing formal yet. Do I have full custody until the dad chooses to fight for shared custody if he wants custody? So that's again, we're going into the issue over here where people or parents believe that I have full custody. And full custody meaning that the father has no custody rights, where the mother can now decide what type of contact the other parent should have or not. So if I'm looking at the facts over here, clearly it's a scenario whereby the father is there, he's alive, he knows the child, etc. So I cannot say that the mother has full custody rights. If the mother feels, and I won't go further with the question, but if the mother feels under these circumstances that she needs to limit the father's rights, the father now says, I want to have contact with the child more often, or I want these specific rights to the child, and the mother feels it's not in the child's best interest, then the mother needs to act in the child's best interest, but then the father will have to approach the court, and the court will now have to determine what is in the child's best interest. So let's move on over here. I do not want to deal specifically with scenarios for specific clients because I don't have a chance to ask additional questions. So I'll just give the general answers, and I'll expect you still to obtain specific advice from somebody to your specific case. The next question, mother secretly relocated with the kids from home in Gauteng to KwaZulu-Natal. After divorce pleadings, it changed without a court order or notice to the father. Both parents sought the primary care of the child ages 2 and 6. Father brought an urgent High Court application to restore status quo of kids back to Gauteng. Court ordered kids to continue residing in KwaZulu-Natal pending fan admitting investigation, and father may have every alternative weekend visitation with the kids in KwaZulu-Natal. Who is liable for the father's travel costs for him to maintain contact in KwaZulu-Natal? Both parents are employed and similar salaries. The long and the short of the matter is the party that has to travel to see the child, he's responsible, she's responsible, unless a court orders otherwise. So if you want to see your child, you need to make an effort to see the child. You need to travel to the next province. If you feel that the other parent should pay for that specific cost, and then you need to approach a court, and the court can make such an order. But it's difficult under these circumstances because maybe it is in the child's best interest to have gone to KwaZulu-Natal, and that in the child's best interest, and it will be not in the child's best interest for the child to remain in Gauteng. So for me to say the parent that left the province should pay for the traveling costs, that will be unfair, unless a court of law determines, no, you left to go over to the different province. It costs now the other parent so much money to travel to visit the child, and that parent does not have the necessary funding available. Under those circumstances, we make an order that you should pay half expenses, etc. But the court will have to look at all the factors, but there's no quick answer saying, yes, this parent should pay or that parent should pay. A full inquiry needs to take place, and the court will have to determine what is fair and just and equitable. Okay. Let's go further. Has an annual increase been ruled out in 2015 according to the Maintenance Act? A clerk of the court says for increase to take place, you have to come and reapply every year. So that is a situation whereby usually in the maintenance order, there will be a provision for an annual increase, for argument's sake, saying 10% or 15% or CPI, whatever the case may be. If that is stipulated in a maintenance order, then obviously that must be followed. So I disagree that it has been ruled out. But if a party does not have that provision in the maintenance order, then you need to apply every year for an increase. And the increase will be based upon, not upon CPI or the inflation or by percentage. The increase will be based solely upon what the increase of the child is for that specific year. For argument's sake, if the maintenance order at present is 1,000 Rand, and next year the child actually only costs 500 Rand, there's no reason for an increase. So there is now a basis for a reduction in child maintenance. So for this specific viewer, I advise you, when you apply for a new order, to stipulate in the order that either the CPI, the Consumer Price Index, increase per annum, alternatively have a percentage in over there. And I think a reasonable percentage is between 10 and 12%. I'm just letting some participants in. We can continue. And there's some on the chat as well. I'll just deal with some of those questions as well. One of the questions on the chat is, child's father wants to see him when he wants to. He has never maintained the child since birth. Okay, so under those circumstances, you need to make a decision. If you are the primary caregiver of the child and you and the other parent was never involved in the child, then you must stand your ground. You can say, no, you cannot see the child because I don't believe in the child's best interest to have contact X, Y, and Z. Don't be malicious, don't be vindictive, don't try to spite the other parent. But if you believe it's not in the child's best interest, I do not have any details of the age of the child. She says baby, or he says baby. But then let the other parent approach the court and let the court now determine what's fair. Alternatively, I suggest parents to actually approach maybe a social worker, a mediator, to assist the parties with that. Then we have another question, a live question. Am I allowed to ask questions during the session? Yes, you are. I wanted to inquire regarding a case whereby the father does not have papers. He has been appealing having been denied a work permit since 2016 by the Department of Home Affairs. He is working in spite of this. He is from Zimbabwe and he has approached the court for a parenting plan regarding the 2 daughters. My concern is what happens when he gets deported. So if the father does get deported and he has to now go back to Zimbabwe, and then contact right should either be done via, like we're doing it via Zoom now, or via any social media platform. It's possible under those circumstances that the children can, obviously with the consent of both parents, travel from one country to another country, Zimbabwe. Alternatively, if he gets deported and he gets permission again to come back into South Africa, then he's welcome to visit his kids back in South Africa. But I think these type of issues are best to resolve, with somebody at the Department of Home Affairs, and they can most probably assist you and advise you on how to deal with these type of issues. But let's go to the next question, the next live question. If you were in a short abusive relationship and upon the birth of your son, your ex forced you to sign the surname, to sign his surname to the child. He is not paying maintenance and lives in another province, having excuses to spend time with the child. Okay, so I think we're dealing with a situation over here is where the father asks the mother to register the child under his surname, and is not now providing for the child like he should be doing. But let me go further there. There is still a maintenance hearing pending, being extended all the time as he doesn't pitch up. Can the mother apply for change of the surname to hers, or wait till the court conducts all matters pertaining to custody and maintenance? Now, this is a very interesting question, because when I dealt with these issues in the past, a client will come to me and she will say, I left the father of the child. I would like to change the child's surname back to my surname, my maiden surname, or whatever the case may be. Now, again, we have to look in the child's best interest, but here we're dealing with an issue concerning the Department of Home Affairs, the Director General, and he's the one that changes surnames, or decides if there's any good reasons for the change of the surname. So under those circumstances, if the father does not want to agree to the change in the surname, it needs to go to a tribunal. It needs to go to a court of law, where the court will now have to determine what is best for the child. Is it best for the child to have the father's surname, which it always had, or is it best for the child to have the mother's surname? So how does the court determine that? Because it's a surname. So we have to look at various factors. The mother might say, for example, the father's not paying maintenance, he's not involved in the child's life. Why might the child have the father's surname? Another good reason, which you could try, is to stipulate that, and it is factually to do, is to state that when the mother applies to schools, when the mother applies for this, she applies for that, every time, because of the surname change, or because the child does not have the mother's surname, she acquires problems with this school or the specific department, and therefore it will be in the child's best interest for the child to have the mother's surname. So under those circumstances, I will strongly argue that there could be a basis for that. But if the basis is because I left the dad and I don't like the dad anymore, and we separated and we're in bad terms, therefore I want the child to have my surname, that might not be a very good reason. So always look what is best for the child. And once you determine it is best for the child for a certain course of conduct to take place, then under those circumstances, you proceed with whatever you want. And that's also how the courts apply. I mean, many times we go to the maintenance court, the custody court, children's court, the high court, etc. And judges, magistrates keep on mentioning this is the child's best interest, and this is what I believe is in the child's best interest. The same with the expert reports, family advocate reports, social worker reports, psychologist reports, all of them keep on saying what is in child's best interest, and that must be applied.